A sponsor in a real estate syndication has a capital gap. The senior loan came in lower than expected, and investors are asking about yield. The sponsor asks, can we offer preferred equity investments in this Regulation D private placement, or is this really a waterfall priority we have to draft? This is syndication attorney field notes with Tilden Muschetti. I'm Tilden Muschetti, a syndication attorney. Today's field note is about preferred equity as a drafting tool in a sponsor capital raise. The direct answer is this: preferred equity is a priority position you draft. It is not a promise that cash will always be there. It is a set of priority distribution rights in the LLC operating agreement. Waterfall just means the order in which money is paid out. In the capital stack, preferred equity sits below senior debt and above common equity. Priority over common, subordinate to the bank. If cash flow pauses, careful drafting can make the missed amount a soft accrual instead of a hard default. If the terms look too much like repayment on a loan, the structure can raise debt reclassification concerns. The common mistake is treating preferred equity like a standard product. A sponsor may say, we will just add a preferred class and give those investors a target return. But preferred equity does not come with one set of standard terms. The rights exist only because the operating agreement creates them. The distribution waterfall is not a side schedule. It is the machinery that decides who gets paid, when they get paid, and what happens if there is not enough cash. That is why the label does not do the work. The drafting does. Why is the mistake so tempting? Because the business problem is real. A sponsor may have a deal that still makes sense, but the capital stack changed. Maybe interest rates moved. Maybe the senior lender reduced loan proceeds. Maybe the equity raise came in a little short. At that point, the sponsor has choices. Raise more common equity, which can dilute the sponsor and the early investors. Add mezzanine debt, which may bring a rigid payment schedule and lender concerns. Or create preferred equity, which may give new investors priority economics without turning them into a creditor with note-style remedies. That middle lane is the reason preferred equity is used, but the middle lane only works if the document keeps the equity character. A preferred investor can be first in line ahead of common equity. That does not mean the investor is a lender. It also does not mean the investor gets paid no matter what the property does. This is where soft accrual versus hard default matters. With a promissory note, there is usually a payment schedule. If a payment is missed, the note may allow default remedies depending on the documents. That is a hard default framework. With properly drafted preferred equity, a missed preferred distribution is handled differently. The unpaid amount is tracked. It becomes an arrearage or preferred balance. It waits for future cash flow, a refinance, or a sale. Common equity usually waits behind that balance. But the missed distribution by itself is not treated like a missed loan payment. That is the sponsor value, soft accrual instead of a hard default. Here is a simple example. Assume a sponsor is buying an apartment property. The deal expected a larger senior loan, but the final loan proceeds are $1 million short. The sponsor does not want to raise another $1 million of common equity because that changes the split for everyone. The senior lender is not comfortable with mezzanine debt. So the sponsor considers a preferred equity class. The operating agreement says the preferred class gets an 8% target return before common equity receives profit distributions. That is a priority distribution right. It is not a statement that the property will always have the money. Now assume leasing slows for 1 quarter. Under the waterfall, the preferred class would have received $80,000, but the property only has $40,000 available after operating costs and debt service. If the preferred equity is drafted correctly, the unpaid $40,000 is added to the preferred balance. It is carried forward. When cash flow improves or when there is a refinance or sale, that balance is paid according to the waterfall before common equity participates. That is different from a promissory note. With a note, the missed $40,000 may put the borrower into default. Depending on the note and loan documents, the investor may have remedies that change the leverage in the deal. Same economic stress, very different legal result. So what should a sponsor not assume? First, do not assume the senior lender will ignore the structure just because it is called equity. Senior lender covenants still matter. Some loan documents limit other capital rights, liens, transfers, or claims against the property. If the preferred terms start to look like a second loan, the bank may have a problem with it. Second, do not assume the tax and accounting answer follows the label. If the document says the sponsor has to redeem the preferred equity on a date certain or has an unconditional duty to pay the capital back, the instrument starts to look more like debt. That is where debt reclassification comes back into the conversation. The lawyer drafts the rights. The CPA reviews the tax and accounting treatment. Third, do not assume the offering words are harmless. The private placement memorandum, or PPM, may clearly say that distributions depend on property performance and may pause. But if the pitch deck makes the preferred return sound certain, the documents are telling different stories. The deck has to match the PPM. The safer framing is priority, not certainty. Call it a target return. Explain the priority distribution rights. Explain that preferred investors are ahead of common equity in the waterfall. Also explain that real estate cash flow can change and unpaid amounts may accrue rather than being paid on schedule. That kind of plain wording matters. If an investor understands the structure up front, a missed quarter is less likely to feel like a broken promise. The investor was told they had priority. They were not told the property could never have a slow period. Final field note. Preferred equity is not a yield product you select off a shelf. It is architecture inside the operating agreement. For a sponsor, the key question is not simply, what return can we show investors? The better question is, what rights are we drafting? Where do those rights sit in the waterfall? And do the loan documents, tax review, PPM, and pitch deck all tell the same story? Preferred equity can be useful because it gives cautious capital a first position ahead of common equity while leaving the sponsor room to handle uneven cash flow. But that only works when the structure is drafted as equity. The label does not do the work the drafting does.